I'd like to welcome everybody. My name's Scott Noling, and I'm the president of the Health Law Society here at WMU Cooley. And I have the distinct honor of welcoming you all here today. So welcome, and that was an honor, and thanks for joining us. Before I turn things over to Adam Ostrander, who is the treasurer of the Health Law Society, aka the money man of HLS, I'd like to let you know he's going to introduce the panelists and serve as our moderator. But I'd like to share a little bit about the Health Law Society and reserve a thank you for our advisor who is in the middle of class but will join us momentarily. So briefly, the Cooley Health Law Society promotes student awareness of health law careers, elevates awareness of health law, health policy, and health justice issues for both students and practicing attorneys, and nurtures career opportunities for WMU Cooley students interested in careers in health law. We conduct educational offerings like the one that we're participating in today. We also encourage participation in national health law moot court competitions and hope to be soon instituting a Michigan Health Lawyer of the Year award on an annual basis. But we also welcome fresh blood and new ideas. So if you're interested in joining us as a student, please do so. And I'd also like to very briefly recognize Professor Lauren Rousseau, who is still teaching a class, I believe. So I'm going to kind of reserve the thank you for her, but she has been instrumental in putting this program together. So with that, let me please turn the panelists over to Adam Ostrander. Adam, take it away.
Thank you very much, Scott. So I am going to introduce our panelists, our distinguished panelists. I will say, I think we've got quite a catch here. Afterwards, I am going to just kind of be asking the questions. I think moderator is maybe not the appropriate word so much as MC. I think I'm planning on having our panelists really kind of take center stage and take it away and have a very discussion focused panel here today. We will, I have some prepared questions, but we're going to reserve some time at the end as well for questions from just our audience members here as well. So in no particular order, we have Peter Jacobson, Professor Emeritus of Health Law and Policy at the University of Michigan School of Public Health. He has spent a great deal of his career studying the impact of law and the courts on healthcare policy, as well as equity in health. He served as an editor for the Journal of Health Politics, Policy, and Law, and has served on the board of directors for various national and local healthcare organizations. We have Lisa Nagele-Piazza, and I really hope I said that correctly. Thank you. Who is the senior legal editor for the Society for Human Resource Management. Aside from holding a Juris Doctor, she has degrees in international business law and in human resources. She writes about a wide variety of legal topics, but focuses primarily on state and federal employment law developments for the Society for Human Resource Management. She's written a great deal recently about return to office challenges, safety procedures, and workplace vaccine guidelines. We have Susan Wiltsie, partner at Hunt and Andrews Kurth in Washington, D.C. Her practice focuses primarily on labor, employment, OSHA compliance, and pandemic preparedness. She has a wealth of experience representing employers in all aspects of the employer-employee relationship, in that she's been practicing in that field for 30 years. She is currently defending a variety of cases in COVID-related OSHA suits. We also have Linda Moroney, who, when she's not representing nonprofit healthcare systems in a variety of circumstances, including compliance, she's often busy working diligently on the board of directors for the American Health Lawyers Association. Throughout her career, she's been a partner with multiple national firms and has also been the chief legal officer at a regional healthcare system. All of our distinguished panelists have been involved in some form or another in the developments in law and litigation surrounding the COVID-19 pandemic, and we are very thankful that you're here with us today to share some of your knowledge and perspectives. So I guess to kick things off, we've seen countless suits arising out of COVID-19 responses against states and governors and employers, hospitals, schools, and so on. It's a very broad question, but what do you think will be the most hotly contested form of COVID-19 related litigation that we can expect to see in the future, both short-term and long-term? Let's start with Professor Jacobson.
Hi, thanks, Adam. From a public health perspective, I think the key litigation is going to be over public health powers. What we've seen so far is a focus on the emergency declarations in Michigan and Wisconsin particularly, but in other states as well. But that litigation is short term. The longer term concern is the challenge to the ability of local health departments to develop, and state health departments to promulgate, implement, and execute orders protecting the public's health, particularly if there is a resurgence of the virus or in the future new viruses. I'll just say that there's a similar set of lawsuits likely over mandates. So far, the mandates have been upheld, but I think they'll be under continuing challenge. Suffice it to say, from my perspective, the big concern is whether the litigation will undermine the ability of local health departments to protect the public.
Thank you very much. In no particular order, Ms. Wiltsie, do you have any thoughts on the question or on anything that Professor Jacobson said?
Well, I look at the question from the standpoint of employment, because of course that's what I do. And I don't think that the current litigation that we're seeing falls into any particular category. We have thousands of workers' comp cases that are being contested. We have the OSHA litigation, state plan and federal OSHA. We have personal injury litigation. All of that is really in the somewhat of the early stages. The cases that I'm defending currently are from fact patterns at the beginning of the pandemic. The common denominator in all of that is the causation issue. So I'm answering your question not in a siloed way, but in a comprehensive way. No one can win, not the government, not a private litigant, if they don't prove where someone got COVID. And as depending on which side of this issue you're on, it can look like, in my side, sometimes it looks like a governmental approach is that every person in America with a job who got COVID got it at work. But I'm a little biased that way. But it's an intensely complicated issue and has given rise to resurgence of careers from many, many epidemiologists who might have been looking at retirement came back for this one.
Thank you very much. And no, absolutely, a comprehensive answer is certainly what we're aiming for. So thank you. Lisa, do you have any thoughts about? You said same thing. The question itself, or jumping off anything that's already been said.
Yeah, absolutely. And also my perspective being the employer in the workplace and workplace compliance. I think that we all know, as almost all of us have experienced, overnight we went from being in the office to working from home, and that was quite a change. Some people employees who are exempt from overtime rules, they might be used to more flexibility working from home, but a lot of people who are non-exempt also started working from home, and employers as well as the employees might not have been ready for that change. So I think we'll continue to see wage and hour issues. Were employees paid properly when they were working from home? Were all of their hours captured? And you know, other rules such as in California for non-exempt employees, you have very strict meal and rest period laws. And then also maybe duties had changed. So somebody who's traditionally an exempt employee was performing more non-exempt duties. And there has been some lenience because of the state of emergency. The Department of Labor and even the state of California, that, you know, there's been discussion about, you know, how strictly those rules apply during a state of emergency. But I think we'll continue to see those issues litigated as well.
Wonderful. Thank you very much. And then last but not least, Ms. Moroney, do you have any thoughts about the question itself and anything else that's been said so far?
Well, I would echo everything that has been said. You know, I'll do cleanup here with the kitchen sink approach. You know, I mean, this is a litigator's dream, frankly. And Susan, I hope you're reaping the benefits. You know, I sort of put the types of claims into various buckets, and I came up with 4 ready buckets. One from, you know, the people who suffered real health harm or their surviving family members. You know, patients or surviving family members, members of the general public that were out, you know, going about life that might try to assert claims regardless of measures that have been enacted to protect against claims, but they might sue airlines, they might try to sue hotels, restaurants, other public forums, healthcare providers versus their employers, students, teachers, staff at educational institutions, etc. One bucket. Another bucket would be those at the other end of the spectrum who feel like all of the restrictions presented such unnecessary barriers to them that arose to the level of actionable harm. You know, those who, for example, suffered as a result of virtual learning. Those who had bad outcomes or perhaps lost opportunities because of what they perceived as unduly burdensome restrictions. A third bucket would be, as you've indicated already, Susan, the employment-related claims, and Lisa as well. I do think that we will continue to see a raft of claims from employees who feel like they were retaliated against or maybe even terminated altogether for speaking out about concerns about worker safety or patient safety in the workplace. There was a First Circuit decision recently that related actually back to conduct prior to the pandemic, where a Maine hospital employee, the state of Maine, had expressed in a public, I think, editorial with the local newspaper concerns about patient and workplace safety, and they upheld the employee's position in that appeal. So I would expect to see more of those claims. And then finally, the last bucket I would say is claims associated with shifting to what I would call the new normal, the return to work, as Lisa knows all too well. You know, claims against employees who employers who force their workers to return to the workplace prematurely or perceived as prematurely without necessary or appropriate precautions. Potential, again, you know, purported discriminatory treatment of workers who maybe have health conditions or who of their own volition have chosen not to get vaccinated. So much more to come on the horizon.
Very quickly, a follow-up kind of question. Are we seeing much litigation over resource allocation, for example, taking patients off of ventilators when it looks like they can't survive? Are we seeing any lawsuits like that from patients?
I'm not aware of any so far, but I think it's certainly reasonable to anticipate. You know, we're still so quick, so soon here. What could evolve over the periods of the statute of limitation ahead is only to be determined.
Right, and that's what differentiates the employment and hospital or non-governmental litigation from the immediacy of the litigation over the executive orders or the health department orders, which have driven the litigation so far.
And that is absolutely interesting. And I think the confluence there is also incredibly interesting. The hospital employer confluence, that intersection there, which leads just perfectly into my my second question that I had for the panel. We know that some employers and schools are requiring their employees to be vaccinated to return to work. In fact, I think it was a district court in Texas recently ruled in favor of a hospital employer requiring their frontline healthcare workers to be vaccinated. Given the current OSHA guidelines and the current political and legal landscapes, do you think that these requirements would likely survive lawsuits targeting them in the long term? And if so, are there any boundaries that these employers or schools or what have you might need to be wary of that could lead to further legal issues such as ADA implications or confidentiality concerns? In no particular order, Ms. Wiltsie, if you want to jump in. Oh, I think you're muted. I'm sorry.
Sorry, we're in the first wave of these cases about mandatory vaccination because all of the vaccines are still emergency use authorization. And the cases that we've seen so far and the attorney demand letters that I see are based on a provision in the PrEP Act that says that vaccination is voluntary for an EUA vaccine, which is of course true, but it doesn't follow the next logical leap of these litigants, which is that somehow that has a bearing on employment. Certainly you can choose to not be vaccinated, as regrettably many people have, but that doesn't protect the individual from the consequences of that decision. So in which case, if their employer mandates and they don't have an ADA carve out or a religious carve out that would give them the legal right to decline, they need to get vaccinated or they find another place to work. That's, I think, the gist of it now. I think those cases will get even harder to advance once we have a vaccine that is fully licensed, because so far they're all of these cases have to do with the PrEP Act or some really insane claims under the Nuremberg Code and the like. Once the vaccines are fully licensed, I think the litigation, at least from my employment perspective, the litigation will become exclusively related to the ADA and the religious carve-outs, particularly the really interesting issue that I foresee in the future, which is whether or not the anti-vaxxers organizational structure is considered to be a religion. I view that as a potential fascinating issue that I think is inevitable.
And I'll be frank, I hadn't considered something like that. That is very interesting, and I think that would be a really interesting case that would end up in some textbooks, I think.
Well, I think for your study on this issue, if you look at the cases that have been brought on using a religious argument under the Church of Body Modification, you might see where I'm going with this. So I'm not sure which came first, the Church of Body Modification or employee claims that they did not have to abide by dress code policies with respect to piercings. But however that chronology worked, we ended up with a number of cases and certainly a number of claims that don't get to litigation, where employees claim that the religion of the Church of Body Modification means that they don't have to comply with the dress code. So, you know, law abhors a vacuum, just like everything else. So we don't currently have really we have hardly any religions that actually would require as a tenet of the faith not to be vaccinated. And we have a whole bunch of people who don't want to get vaccinated. So I think something's going to happen there. I could be wrong, but that's what I think is going to happen.
Thank you very much. Ms. Nagele-Piazza, if you want to speak to the question or anything that Ms. Wiltsie said, that would be wonderful.
Yeah, sure. And here I am with the typical, cat making an appearance in the Zoom call here. Yeah, I think that, with everything workplace compliance related, that consistency is going to be key. So, when we're looking at potential litigation, from the employer perspective, we're looking at, was everybody treated, fairly and consistently? And so, those claims on whether it's somebody needed a reasonable accommodation, that's medical related, disability related, was that addressed properly? Was a sincerely held religious belief treated as such and appropriately? So I think that is a place where you're going to see a lot of claims, with as far as the, and just echo everything that the lawsuits that are saying you can't mandate a vaccine, particularly after they're fully authorized. I don't think that there's going to be much weight to them. And as we're seeing, maybe there's really not much weight to them now, anyway. So yeah, I just think that, and also we want to make sure too that any policies, if an employer, for example, has policies that frontline workers in high-risk positions are required to be vaccinated, but maybe not other employees. They just want to be careful about how those policies are rolled out, because that's another potential source for litigation. And considering why do we want our workers? Why do we want to mandate a vaccine if everybody's working from home full time? That doesn't seem to make as much sense. So those are just some of the things to consider.
So not just the policies themselves, but also the motivation and the method of carrying it out.
Absolutely.
Okay, very interesting. Thank you. And then Ms. Moroney, if you want to jump in on the question, the responses, anything.
Yeah, actually, I would really be interested in my panelists, my co-panelists' reactions to actions like those in the state of Montana. And many of you may be aware that the state of Montana enacted legislation that actually forbids, it's an absolute prohibition on vaccines as a requirement for employment, for continued employment or for commencement of employment. And obviously that puts hospitals and schools and other organizations in the state of Montana in a very difficult position. And many of them are sort of in the mode right now of, well, be careful what you ask for here, because we're going to have to substantially conform the way we deliver services, not just in the healthcare setting, but in other environments as well, if we can't ensure the safety of our patients, our visitors, and our workers. So just would love to hear the co-panelists' reaction to that, and whether we think ultimately those sorts of legislative maneuvers will proliferate on the one hand or ultimately be overturned on the other.
I was going to ask Professor Jacobson, both your thoughts on the question, but also your thoughts on Ms. Moroney's question there.
So I'll really yield to Susan and Lisa on that question, because I think they're more well versed. My gut reaction to it is that it won't survive a challenge, but I can't tell you why. It's just sort of a response that it's the government going too far to intrude into the employment space. But we have all sorts of regulations that constrict what an employer can do. We have OSHA regulations, for example. So I'll defer to Susan and Lisa for a better explanation than I can give at this point. As to the broader question, again, we have to make the public-private distinction. I've actually been surprised that the mandates from the states and the Centers for Disease Control, CDC's eviction mandate to block evictions, and the mask mandates have been upheld even Justice Thomas refused to overturn a mask mandate earlier this month. So far, in some, the mandates on the public side have been upheld and the challenges have lost. I expect that to continue, but we may start to see a split in the circuit courts as these cases make their way. And at that point, the Supreme Court may have to decide. If the lower courts continue to uphold the mandates, Justice Thomas's action suggests that the Supreme Court will not review those cases.
Okay, very interesting. And I'll tell you, normally, so I was going to move on, but I'd love to hear from both Susan and Lisa about Linda's kind of proposed question there about Montana as well. So how about Susan? And yeah, I forget that that should be something I should do is say. I'm sorry.
That's fine. So certainly I hope, and I know my clients hope, that Montana remains an outlier. I think that it's a wonderful thing that there aren't a ton of huge nationwide companies that have their headquarters in Montana. So I don't know how much this is going to be able to stick, right? If you're a business with a headquarters in Kansas City and you've got employees all over the country, including those employees that are working remotely and reporting in to, offices in other places. I mean, just how many of those people really work for a Montana employer in Montana? And I think it would be pretty ridiculously hard for the government to try to pursue an employer with headquarters elsewhere. And I think it would be interesting to see that litigation. Otherwise, it's going to be incumbent on the individual to say, hey, you can't give me this mandate because I have the rights of the citizens of Montana. And I don't think that the Montanan, I haven't read it carefully, but that it includes any kind of private right of action. And so what's the remedy for this Montanan? I think from the employer perspective, the remedy is, you get fired, work it out. But I don't know whether the government of Montana has another remedy in mind.
Okay, wonderful. Thank you. And Lisa, your thoughts on it?
Yeah, I know that I'm not familiar with the specifics of the Montana statute, although I do know that it's basically protecting vaccination status. But I do believe there are some certain carve-outs for healthcare in there, although it might be limited. But yeah, I just kind of agree with my co-panelists that I see a hard time. I have a hard time seeing this passing sort of a legal challenge. And I think too that the thing that employers should be looking at is under OSHA, whether they're covered by the new emergency temporary standard for certain healthcare employers or not. Every employer, has a duty to provide a workplace under the Occupational Safety and Health Act that's free from known hazards. And so there's really just kind of a sort of conflict there. And I think employers are focused on that first. And so it's a matter of their level of risk that they want to take when they encounter these kind of situations. Do they really think that this Montana law is going to stand, and is their duty stronger to protect their workers, their patients from known hazards?
Wonderful. Thank you very much. Thank you very much, and thank you, Linda, for bringing that to the table, because that's very interesting, and I think we all really appreciated hearing everyone's thoughts on it. So moving on to the next question I had prepared, which kind of springboards off of this most recent one, where we were talking about whether employers or schools or hospitals can, objectively, can they require the vaccinations? So moving beyond that into maybe a little bit more subjective territory, should they be required to, or should they require their employees or students or what have you to get vaccinated? Lisa, if you could start us off.
Yeah, as I say, I sort of live more in this subjective realm here because a lot of times with our, our members are HR professionals and employers, and we've just kind of been encouraging them to take a look at what policies make the most sense for them. If they do have risk employees in high risk positions, whether that be in healthcare or in retail, hospitality. Maybe it makes more sense to have a mandate. Whereas if you have office workers who can work remotely, who can easily stay 6 feet apart, maybe that doesn't, maybe it's not as essential to have a mandate. And we have found that a lot of employers are actually encouraging rather than requiring vaccination. And of course they have to be careful with what incentives that they offer for that too. They want to offer something that encourages people to get vaccinated, but not so much that it kind of turns into a mandate. So there's a balance there as well. But again, like it just really depends. If your workers can be remote, does it make sense? And then it comes down to also just company culture as well. Do you require flu shots? Do you encourage flu shots? Kind of looking at your other policies, and are you more lenient with workplace rules, or are you more stringent? And that might also be a guiding factor.
Okay, thank you very much. And Linda, do you have any thoughts on just the question as a whole, or anything that Lisa said?
Yeah, obviously the question of whether you should is necessarily subjective, and it's on every individual's own assessment of the risks and their own circumstances and their experiences, their own and those of their family and friends and coworkers, et cetera. We all see the world through the lens of our own experience here, or through the lens of the TV network that we get our news from, as the case may be. But in any event, I think from the employer's standpoint, you really need to consider the collateral consequences of a requirement. May it inflame your workforce, for example? May it encourage union organizing activities, for example? Are there other positive or negative impacts, short-term or long-term? Is it a slippery slope, as Lisa's comment alluded to? How does this pertain to your other policies and your potential future policies as the employer? I do think it's interesting as we sort of just try to be more objective about this and look at kind of the statistics. It's interesting to think about how companies and public institutions have navigated this. If you look at the numbers alone, I mean, I can argue this both ways. On the one hand, you might say that back in January, it might have been more supportable to mandate vaccines, just given the scale of the crisis at that point. I mean, we had, hospitals turning away patients, morgues overrun with bodies. In India, they're burning bodies out in parking lots. It was just so overwhelming and, obviously created a sense of desperation. Yet here we are a few months later, and the numbers have plummeted. I mean, barring the most recent Delta variant uptick, the numbers have plummeted. So it raises the question, with only about 2/3 of the US adult population vaccinated, is it really necessary as a public health measure for us to have mandated vaccination for all of the population? On the flip side, I could also argue that the vaccine mandates now are more defensible than ever, because with the passage of time, we have more and more evidence that they are effective in stopping the spread of the disease, and relatively little evidence of adverse harm to the vaccinated public.
Thank you very much. Thank you very much. And Professor Jacobson, do you have any thoughts both about the question as a whole, or any comments made thus far?
Sure. All the comments are very insightful and perceptive. My answer is yes, mandate them. Do it now, protect your workforce, protect the public using your services, particularly in hospitals, health systems, and other healthcare segments of the healthcare enterprise. But we need to, I think, go back and say, first, FDA, get off your collective tuchuses and get moved to certify the vaccines as safe and effective. The evidence is overwhelming. Before we went live, I mentioned a statistic from Los Angeles County, which has now a severe outbreak based on the Delta variant that Linda alluded to. Not one case in hospitals in LA County that are being overwhelmed is of someone who has been vaccinated. These are safe, effective, and I would say, yes, we should mandate them with the caveats that we have to protect people who are disabled, who may be immunocompromised, people who have medical issues. They can wear masks. There's a least restrictive alternative, or a lesser restrictive alternative, I should say, in saying if you're not getting vaccinated, then you must wear a mask to protect your fellow workers and the public. So with those caveats, as a public health measure, because it's not just the Delta variant that we need to be concerned about. If we don't reach herd immunity, and the rate has slowed of vaccinations, and in some states, Tennessee, we're seeing a real backsliding on the need for vaccinations or the willingness of public elected officials to encourage the public to get vaccinated. We need to then be concerned about other variants that will be even more contagious than and disastrous than the Delta variant.
Thank you very much, Peter. And last but not least, Susan, if you could speak to the broader question and or any comments made thus far.
Yes, I'm pretty aligned with the professor on this one. Let's just start, and the students on the call, I think you could spend many enjoyable, fascinating hours looking up the history of the government mandating vaccination in our country. And I think you'd be surprised to see that it is largely a more of a two-step process, like I discussed earlier. The federal government has a very limited ability to directly mandate vaccination. They mandate vaccination only as a way that the individual, a step the individual has to undertake in order to get a benefit the individual wants. For example, in immigration, we have lots and lots of vaccine requirements for people who want to come to this country. But with some limited exceptions, the only way the federal government can make someone get a shot is if that person is in the US military. Otherwise, they're doing it in the same way a private employer is. They're saying if you want to work for DOT, you have to get vaccinated. But that's the government acting as an employer, not the government acting so much as a state actor. Because the legal considerations in who is mandating the vaccine are starkly different. If it's a public actor, then you have at least 4 potential US constitutional challenges. And if it's a state actor, a state governmental actor, you have state constitutional challenges as well as challenges that are embedded in statutory and common privacy law. So it ends up looking, unfortunately, like the private employer community is going to end up carrying the greatest burden here, which bothers me on so many levels. if it is going to be the private employers who have to make the decision whether or not to mandate or not for the public good, then the least that somebody in the government could do was to provide some protection or more protection or even clearer guidance. So if employers, private employers end up being the ones who mandate vaccination in order to increase vaccination numbers, then they don't spend the next 6 years of their life defending litigation. So, but employers, honestly, right now in some industries are, no matter what, are not going to mandate vaccination because of the labor shortage. It's very, very difficult to fill the slots in the hospitality industry and in the unskilled worker, manual labor areas. Those jobs are not getting filled. And there's a tremendous effort to try to fill them. And my clients won't even consider mandatory vaccination when there's this level of difficulty in some parts of the country in filling these slots in the first place.
Thank you very much. And that's, yeah, it's really fascinating to see the interplay of all of the consequences and the results of the pandemic and the responses thereto kind of coming together to create these additional issues or problems or barriers. Thank you.
I just wanted to add that's also where you see just the encouragement from employers coming in too, because they have this conflict between where you now have this huge talent shortage that we're trying to deal with as a result of the pandemic as well. And so even you go into a convenience store and you see signs that say $300 bonus if you get your vaccine in the first couple months of employment and all this. So it's this combined issue now of wanting to vaccinate your workforce, wanting to find employees, and wanting to provide a safe workplace.
And that's very interesting. And that too, I'm sure that's a struggle that a lot of employers are trying to meet, is how to encourage without being coercive. Moving on to the next question that I had, and I know it's very broad. I don't know how much of a springboard it can really be for discussion, but it was just so interesting, and with so many of our panelists focusing on employment law or compliance, I thought that it would be good to ask about the inconsistencies in addressing the pandemic at different levels of government, and what kind of challenges that the conflict of laws has presented in the COVID-19 crisis, and what kind of challenges it continues to pose. So if I could, Linda, why don't you start us off?
I'm probably the least equipped to answer this one among the panelists. I know you all have well-formed opinions on this one. My Montana example earlier, though, it cemented for me that your access to vaccines, your basic workplace or school safety issues, it just seems so arbitrary that we have such variability in all of these issues depending on whether I'm standing 2 feet on one side of a state line versus 2 feet on the other side of the state line. I think it's really particularly hard to navigate for people who reside in one state, maybe have their kids in school in that state and work across the border. Just lots and lots of challenges, both for employers and for individual workers and public citizens. It seems ultimately very arbitrary, and you'd like to see something more in the way of cohesiveness ultimately. And if Professor Jacobson has ideas about how we can promote cohesiveness in our overall scheme, I think we'd all be well served.
Professor Jacobson, yeah, if you have any thoughts.
Thank you very much. And if I did, I'd be running for governor of some state right now. Yeah, we can spend the next hour talking about how experiences like COVID-19 further exacerbated the differences in the polarization in society, which in part gets to the conundrum here. Susan referred to an important point when she talked about the military, where the military doesn't have the a soldier can be mandated to be vaccinated. So if the government is really serious about the need for mandate for vaccine uptake, why doesn't the military take the first step? Why defer to the employers without a similar governmental commitment to this? I think that would go a long way toward giving some space for employers to if they're uncertain, to say, well, the government's actually doing what it can. We need to follow that model. To the specific question, and to Linda's point about cohesiveness, one of the things we're seeing is that through the public health orders, we're seeing far more opposition to what I think are fairly reasonable constraints. To your point, Linda, earlier about the January surge, we still saw a lot of resistance to closing businesses for legitimate reasons, for not returning to in-person education. But one of the big challenges to this, and so the inability to have a rational discussion at that point meant that we weren't, that sorry, let me strike that. What you see, or what we've seen in both Michigan and Wisconsin, is the inability of the elected officials to sit down in the same room and come to a reasonable agreement around how far to go, how do we protect the people, stop the incessant power disputes, and protect the public. So that's really the core of how you get cohesiveness, that the elected officials can say to their respective constituencies, we need to solve this together. That said, in response to Adam's question, the big issue from a public health perspective that was exposed in challenge, that is, in the COVID response, at least in Michigan and I think in many other states, is the lack of enforceability. That what you had in various parts of the state were essentially resistance to the orders and law enforcement's unwillingness to enforce, leaving it to public health, which really isn't in a position to enforce the laws without full support from law enforcement. Going forward, that's a huge problem that needs to be addressed between public health, among public health and law enforcement, because even if there's no second once-in-a-century pandemic, we're going to have other outbreaks. We're going to have lots of disputes over environmental protections, water, etc. And if the resistance continues, public health is in trouble, and the health of the people in the state of Michigan will be affected adversely.
Thank you very much, Professor. And real quick, normally I was going to save questions for the end, but I see that our president McGrath popped his hand up there, and certainly I would love if he could weigh in. I know he also has we benefit from his experience both as an attorney, but also his background in public health. President McGrath?
I just had a quick question for Professor Jacobson about what he was just talking about, kind of. Over a decade ago, Larry Gostin and others were instrumental in getting the model public health laws, model emergency powers acts. And there was a cadre of other law professors at the time who were taking the opposite approach, saying, the common law protections are so strong, don't mess with them. And I'm wondering, are we finding out if either side was right?
So that's a great question, and it's, I don't want to take up a lot of time for that. I'm happy to have an offline discussion with you about that. The short answer is that the New England public health lawyers opposed the Model Preparedness Act because they felt it gave the government too much power at the expense of individual civil liberties. With COVID, what we've seen is a backtracking from the opposition and a recognition that while you have to protect civil rights, the government has to get the virus under control. And so there's been, if you will, a regression to the mean, and the mean being the need to protect the public first without unduly intruding into individual civil rights, which gets to a lot of, I think, the employment discussion we've had, and that is the employer's struggle not to be coercive, but to want to protect the workplace. So in a sense, both sides are dealing with the same problem within a different legal structure or a legal framework.
Thank you so much.
Yes, thank you very much, Professor Jacobson. If I could get then Ms. Wiltsie's thoughts on kind of that interplay and cohesiveness as a whole here in the response to the pandemic.
Yes, and I find myself once again agreeing with the professor. So just a couple points, and then I'll go specifically to the employment issue. For the law students, there's so many fascinating issues buried in this. One of the strongest remaining pieces of federalism is the police power of the states to regulate health. And that's done obviously through the police power. So you had a situation, or you would have if it was implemented properly, where you could get essentially like a traffic ticket for your failure to wear a mask or the like. But really, that just didn't happen. The departments of health issued citations, but I think, well, I know for certain within my client group, there were only 3 instances throughout COVID where anyone that they knew of or anyone in their workplace was given any kind of citation. So you had, I know I'm pounding the drum here, but you had private employers in the role of the government that they could sanction their employees who weren't following the requirements, but they couldn't call up, the police station and say, hey, I've got a problem with Betty who won't ever wear a mask, because there was never another side of that issue. At least, that's my opinion on it. The other fascinating issue buried in here for the law students is this whole individual rights issue, right? It makes strange bedfellows, because typically it's a progressive ideology that the individual voice can sometimes be paramount to the collective voice when people are victimized or disenfranchised in any way. But here, the individual voice is crushing us. So how do we reconcile that? I don't have an answer to it. I just throw it out to follow up on the professor's comments. But to your specific question of whether or what the biggest challenge is, it kind of follows on the heels of both of those issues. If you're in a jurisdiction where, as a matter of public law, COVID's over, and you're an employer who has to maintain and wants to, let's be clear, wants to maintain a safe and healthful workplace for their employees, for their customers, and their visitors. If the overwhelming viewpoint in that jurisdiction is that COVID is over, the resistance to enforcing the workplace policies that are necessary to be enforced in order to have a safe workplace is unbelievable. And just the one example, right? Let's talk about the CDC guidance that says unvaccinated have to wear masks. The key issue that I get as an advice question every single day, multiple days, is honor system or not? Well, what do you think, right? Is the honor system reasonably going to work here? Like, you employees who aren't vaccinated, you just on your own wear a mask, and we're not going to find out your vaccination status. We're not going to discipline and discharge you. I have strong opinions that doesn't work. But in some parts of this country, in order to keep people coming to your, keep people showing up to work or wanting to work at your location, you have to have flexibility that is directly at odds with your OSHA obligations.
All right, thank you very much, Susan. And I mean, I feel like we could have an entire separate panel discussion on kind of the role of government and private employers, especially even as it just specifically pertains to the pandemic.
Just quickly to Susan's last point, I think about 150 staff from the Houston hospital resigned after the mandate was upheld.
Even for such a large employer, that's a significant number of employees. And then finally, Lisa, if we could get your thoughts on kind of that interplay on different levels and cohesion.
Yeah, I think for law students who are interested in going into employment law, the way that you always have to approach it is you look at sort of the federal floor, and then you look at what you have your obligations at the state level and the local level. And through the COVID crisis, there's been such a conflict because, depending on where you live, and as everybody else has talked about, it's just the rules are very different in different locations. And so you have some places like San Francisco just announced for their the city of San Francisco, for high risk workers, they're going to have to be vaccinated by mid-September. And then you have places like in Florida where they're trying to ban businesses from requiring vaccine passports. Of course, if you dig deeper into those bans on vaccine passports, they make great headlines, but really they're not for the most part impacting private employers. Of course, you have your exception in Montana, but I think so. When you're looking at these conflicts of laws, and for multi-state employers, it can get very complicated and confusing and nearly impossible to sort of have a bright line rule across nationwide. So you just kind of have to first look at the bigger picture and just be guided by that duty to provide a safe and healthful workplace first and foremost. And then kind of just look at the individual layers and what affects your organization from there. I mean, as employers, we always ideally look for, can we have some, universal rules that are going to apply and make compliance easier, make administration easier. But the reality is, with just about every aspect of employment law, you are going to have nuances at the state and local level that are going to be a challenge, and employers kind of have to figure out, can they have like a broad rule that gives employees the most possible rights and freedom, or do they have to have kind of carve outs and individual rules for different locations? And that might be different from employer to employer. So yeah, but we're always aspiring for policies that are going to be flexible and apply nationwide, but it doesn't always happen that way.
Well, thank you very much. Thank you, Lisa. And I had made everyone aware. I prepared another question, but I don't think we're going to have time to get to it. I know we told our panelists noon to 1, but if you have still a couple of minutes, we could open this up just for a couple moments to see if we have any questions from our law student audience members here. So feel free I see one. Kat, go ahead, and if you have a question, go for it.
I'm trying to figure out like the best way to word my question, but I have a lot of concerns when it comes to people with disabilities and businesses and different things related to the COVID and the pandemic and mandates and such. As a severe asthmatic, I struggle to wear a mask. In fact, I have had my first severe asthma attack in more than a year towards the beginning of the pandemic, because I was in a very humid building with and people were screaming at me because I pulled my mask down just below my nose so I could breathe a little bit. You know, like so it's not always as simple as just wearing a mask. I'm also incredibly allergic to several things, so I'm nervous to take the vaccine. Then there's also people with like severe autism and stuff who have tactile issues where they can't, you know, they struggle to even get their hair cut. It's not as simple as just wearing a mask. So they wouldn't be able to go somewhere, or they wouldn't be able to, you know, attend something or go out to eat or such, if they are unable to if or medically worried about the vaccine in general, but also can't just wear a mask. I mean, people are already being assaulted out there because they try going somewhere and they just pull their nose down so that way they can breathe. I mean, it's difficult for people with, you know, severe disabilities sometimes to even have anything on their face at all, or their head. I mean, getting a haircut is difficult. So, I mean, I guess I'm not sure, like, where what do we see as helping people in that category? What is, I mean, what are we what do we see as happening to ensure that those people are protected?
Yeah, Lisa, absolutely.
I can take. I'm sorry to hear about that. You know, I think that there are a lot of issues coming up, and employees, from the employer perspective, you know, employees are struggling. This is really hard on everyone, and I think that, you know, you have the Americans with Disabilities Act, and you have equivalent state laws that are going to protect employees who have disabilities that are impacted by the pandemic. And from an employment law perspective, employers have a duty to engage in an interactive process with those employees to determine if a reasonable accommodation can be made. Maybe that's working from home. Maybe that's working in an isolated office so that you're not in contact with other people, or having a different entrance and exit to and from the workplace. There are ways, and it's going to be different for every workplace, depending on the environment, the job duties, the essential functions of the job. But the important thing is for employers to be understanding, be patient, and then also on top of that, take a look at the law, make sure that they are going through that interactive process to see if they can find that reasonable accommodation. And I think that there is some flexibility there. So it's not just, you know, wear a mask or leave. You know, there are other workarounds, and they're going to depend on the individual environment.
Thank you very much, Lisa, and thank you, Kat, for the question. I see Elizabeth Johnson. If you have a question, please.
Hi, thank you, panel, and thank you for putting this on. I really appreciate it. In fact, because I'm in scholarly writing and I'm doing my paper on this very topic, so this has been very helpful. But I just have a few questions. In my research for this topic, I'm looking at all of the lower courts and also Supreme Court decisions. Obviously, Jacobson is a big one. But forgive me for my ignorance, but in law school, okay, we read all these cases, we read judicial opinions, and they always throw in the word reasonable or reasonableness. What exactly is reasonable, correct? So looking at, starting with Jacobson, you know, nothing can be arbitrary or oppressive. That would suggest reasonableness. But then, as our panels have suggested here, you know, hypotheticals of future variants, possible new variances, and that we're going to base public policy on these new variances, these possibilities. How is it reasonable to justify fundamental liberty right restriction? I mean, you're violating people's fundamental liberty rights in terms of mandating masks or vaccines, but you're basing public policy on hypotheticals. I just don't see how that can be reasonable. Also, with the Delta variant, I read somewhere that it has a 0.08% death rate. That's a lot lower than anything else that we've seen. And then COVID in general has a death rate of 0.018, I'm told, or I read that on the CDC website. So I'm just wondering, where do we draw the line on what is reasonable when you're dealing with people's fundamental liberty rights to their personal autonomy? I mean, what if they don't want to get the vaccine because it's right now, it's still in its experimental phase, and it's not had a full backing by the FDA. And also, you can't really say it's safe because there's not been any long-term studies. I mean, I've heard, I think there's 22 cases of children, boys by the age of 11 who have now, after getting the second shot, have heart conditions, health issues. They've had palpitations, heart palpitations. We've seen pilots die because they're at a higher risk of blood clots because of the vaccine. I mean, some people are just waiting it out because they're like, well, I don't know. This doesn't seem, but yet we're just jumping to conclusions without even looking at reasonableness. I was wondering what you guys had to say about that. And again, thank you so much for doing this.
Well, we could spend another hour on that issue alone. So again, this will be a very quick answer. First of all, we have a lot of data showing safety and efficacy of the vaccines. Yes, there are some adverse reactions, low death rates, but not zero. There's every public health official has to balance a variety of factors in determining what kind of mandates are reasonable, what kind of regulations are reasonable. And most came down with conservative governments, state governments, liberal state governments with significant mandates. When certainly at the inception of the virus, nobody has a right to expose others to severe illness and or death. And there is no doubt that people died from COVID at rates that exceeded any other infectious disease other than potentially Ebola, which was a limited exposure. So the fact that there are some intrusions into individual civil liberties to protect the health of the public was entirely a reasonable decision. And note that most governments removed the lockdown as soon as the trend on infectiousness changed and kept other restrictions in place. But we live with lots of restrictions. You have to get a driver's license. You have to wear a helmet. You have to go through metal detectors. You have to get vaccines to enter school for those young children. And this was just a set of restrictions that are reasonable under the circumstances and were lifted when the circumstances changed. But again, it's a long answer, a much longer discussion, I think, that we don't have time for.
Unfortunately not. And I know I was getting some chats about folks that had other questions, and I do apologize. I know that our panelists, we told them noon to 1, and I unfortunately, I would say fortunately, we had some really great discussion that kind of ended up having this last a little bit longer than we'd originally planned. But I do think that we're going to wrap it up with that. I am going to turn it over to Scott for some closing remarks here. So take it away, Scott.
Am I live?
You sure are.
You can hear me. All right, fantastic. So, panel, we overpromised and you over-delivered. So thank you so much for, we knew we had a great panel set up here, and this was just a fantastic discussion. So thank you. I'd also like to thank Adam for doing a great job as MC, moderator, DJ, Jazzy Adam, whatever he wants to go by. And then I'd also like to, now that she's on the line, recognize again Professor Lauren Rousseau as the faculty advisor to the Health Law Society here at Cooley. Her guidance and counsel have been absolutely instrumental in getting the club off the ground And she was also very instrumental and championed this topic particularly throughout our discussions over the last 6 or 8 months. So thank you for all you've done, Professor Rousseau. And with that, thanks everybody for attending. We'll hold future events downstream, but this has just been fabulous. And thanks again, panel. Thanks, Adam, and thanks everybody for attending. And with that, why don't we wrap it up? Thanks a bunch.
Thank you so much.